Continues on immigration enforcement. The media was giddy that somehow Alligator Alcatraz was, quote, shutting down. And we told them that that wasn't true. There have been illegal aliens continuing to be there and being removed and returned to their home country. But they ran with the narrative because some leftist judge ruled implausibly that somehow Florida wasn't allowed to use our own property to help the federal government in this important mission because they didn't do an environmental impact statement. Well, we said we would fight that. We said the mission would continue. And I'm pleased to say that the 11th Circuit Court of Appeals has just stayed that ruling and stayed the case. So Alligator Alcatraz is, in fact, like we've always said, open for business. The mission continues, and we're going to continue leading the way when it comes to immigration enforcement.
Bam! Let's go, let's go, let's go. Let's get all these third world migrants sent home. Sent home. What could be nicer than going home? There's no place like home. Welcome, everybody, to another episode of the Andrew Branca Show. I'm so pleased that you're all here. Man, I have a ton of stuff to cover with all of you today. Of course, Alligator Alcatraz is the headline. Decision out of the 11th Circuit Court of Appeals shuts down the federal judges. One of the things I want to talk with all of you about is that I'm observing these appellate court judges finally being willing to acknowledge that these unelected, black-robed, tyrannical, inferior district trial court federal judges are acting like little hoes and need to be pimp-slapped back into order. I'm seeing these crazy rulings coming out of these district courts and the appellate courts like the same day, issuing stays, demanding, you know how some of these district courts have been machine gunning the Trump White House? I want an update report now, and another one in 20 minutes, and another one 10 minutes after that, and 5 minutes. I'm seeing the appellate courts start to do this to these feckless, unelected, black-robed, tyrannical, inferior district trial court judges. The adults are back in the courtroom. So let's take a look at this. I know it says this Alligator Alcatraz decision is 60 pages. It's not really 60. The majority decision is only about half of that. And that's the only one I'm going to read. The 30 pages of dissent is just some little whining, complaining that they're not getting their way. It's pathetic, as these dissents usually are. So I'm not going to waste your time with that. Let's read the winning position out of the Court of Appeals for the 11th Circuit. By the way, can you just tell this is some progressive Marxist left-wing Trump deranged organization, Friends of the Everglades and Center for Biological Diversity. And of course, some losers, some Native Americans versus the United States of America. I'm on the side of the United States of America. Before three judges, including Lagoa, who is super impressive, folks. I'm going to be keeping my eye on this dude. Man, I'll tell you one thing. This lawfare against Trump has really provided an opportunity for the raising the profile of some truly excellent, non-progressive judges in our federal judiciary. They've really been given an opportunity to shine that they would not have had but for this lawfare against Trump. So, on August 22nd, 2025, the unelected black-robed tyrannical federal district court judge, a woman, of course, issued a preliminary injunction barring Florida and the United States from engaging in any additional construction at the detention facility known as Alligator Alcatraz, ordered the site closed and dismantled. Can you imagine the arrogance, the assumed power of these unelected, black-robed, tyrannical, inferior district trial court judges, supposed to be the apolitical branch of government, Article 3 branch of government, the least accountability to the political will of the American people, ordering the federal government, the president of the United States, about as if he were a clerk in her court, not just ordering the site closed, ordering the site dismantled within 60 days. Of course, the state and federal defendants filed an appeal, asked for a stay of that injunction. By the way, remember what these injunctions are supposed to be doing. A temporary restraining order or a preliminary injunction is supposed to secure the status quo. The status quo when this judge got this case was that Alligator Alcatraz was up and running. That's the status quo. If someone were trying to tear it down, the injunction would stop the party trying to tear it down, trying to change the status quo. But how do these feckless federal judges use their injunctive power? Not to freeze the status quo, to order changes in the status quo, as if they were 733 black-robed dictators, everyone with a veto power over our Article 2 executive branch president, elected by the whole of the American people to carry out our political will. The site closed down and dismantled within 60 days. After careful consideration of this dumbho's injunction, we grant Trump's motion to stay the preliminary injunction. We're not doing that. Homie, factual procedural history. Governor DeSantis declares a state of emergency. On January 6th, DeSantis declared a state of emergency in the state of Florida, directing state law enforcement agencies to take necessary actions to protect Floridians from the impacts of mass illegal migration into the state. Quoting DeSantis, unauthorized alien interdictions in and around Florida have risen to alarming levels not seen for decades. Within the first 2 months of 2023, the first 2 months, U.S. Customs and Border Protection had encountered half a million people. Those are the ones they encountered, folks. Governor DeSantis declared that this heightening immigration crisis was overburdening law enforcement, creating a danger for Floridians. Yes, it's a third world migrant invasion, facilitated, of course, by President Joe Autopen Dementia Biden and the Democrats, who are compelled to import a third world constituency because American citizens will no longer vote for them and their insane progressive policies. As part of the statewide emergency and authorized under Florida Statute 25236, Governor DeSantis empowered the Florida Division of Emergency Management to seek direct agreements with the federal government to meet this emergency, directed all local, state, regional agencies, including law enforcement, to identify personnel needed for response, recovery, and mitigation of this emergency, suspend the effect of any statute, rule, or order that would in any way hinder or delay any mitigation, response, or recovery of this invasion of third world migrants. This I expect will be the key to this decision, because the unelected black-robed tyrannical inferior district trial court judge, she said this all has to be dismantled because of some statute mandating an environmental review. But of course, the governor's order suspended any statute that would hinder addressing this emergency. Construction of Alligator Alcatraz. June 23rd, Florida Department of Emergency Management used those emergency powers to build a detention and deportation facility for illegal migrants, Alligator Alcatraz. Before that, the area was a small but bustling working airport, saw 30,000 landings and takeoffs in the 6 months prior to this being turned into Alligator Alcatraz. 30,000. I've been to the Everglades, folks. 30,000 flights in and out. That sounds like a lot for that area. I would not have guessed that. 4,300 multi-engine planes, 400 business jets, 137 private helicopters, 500 plus military planes, 200 military helicopters. Individuals familiar with the operations of the airport included Ian Gadea Gudicelli. The state emergency response team chief explained that flights taking off from and around the airport were obviously very loud, reverberating well beyond the airport into the surrounding swamp. Every time a flight took off or landed, lights illuminated along the runway. Existing buildings on the site also had outdoor lights that were lit 24/7 and were bright enough to light both the buildings and the surrounding area. Indeed, in spite of the airport's relatively small size, several factors made the airport more disruptive to the surrounding area than a commercial airport might have been. According to Mark Moore, another emergency management employee and pilot, who was flown between 40 and 50 times into and out of the airport. The airport created noise pollution because it was a popular airport for aviation students practicing takeoffs and landings. Oh, that would touch and goes, those are called. That would account for the large number of landings. They're touching their wheels and taking off again, circling, touching their wheels, taking off again and circling. That's the practice, takeoffs and landings. And when they do that, by the way, they never get to altitude. There's no point. You're coming right back down to the runway. So they're flying at lower altitudes closer to humans and animals than would be typical at a non-training airport. The airport did not make pilots follow noise abatement procedures or any procedures to mitigate the noise from aircraft. The site is owned by the government of Florida, Miami-Dade County, located within or adjacent to the Big Cypress National Preserve, a nationally and state-protected ecological sensitive area near the Everglades. Only 2.02% of the land used for Alligator Alcatraz, a tiny grass extension of an airport runway, lies in Miami-Dade County. The entirety of the facility itself is located in Collier County. These are different court districts. This will be important for venue purposes. Miami-Dade County, where only a tiny strip of this land exists, is in the southern district of Florida. Collier County is in the middle district. So I bet the judge, the unelected black-robed, tyrannical, inferior district trial court judge who ordered all of this dismantled, I bet she's a judge in the southern district, where only 2.02% of Alligator Alcatraz exists. I bet that's going to be an issue here for the Court of Appeals. Construction of Alligator Alcatraz started immediately. Kitchen facilities, restrooms, housing, portable industrial lighting, other infrastructure. U.S. Department of Homeland Security, Kristi Noem, posted on Facebook that the facility dubbed Alligator Alcatraz will be funded largely by FEMA. Governor DeSantis also expressed at a June 25th press conference that the facility was requested by the federal government and Florida will be fully reimbursed by the federal government for the cost. Plaintiffs moved to enjoin construction of Alligator Alley. June 27th, Friends of the Everglades Centers for Biological Diversity sued Secretary Noem. Really, they're suing Trump, the Article 2 government. Todd Lyons, Kevin Guthrie, Miami-Dade officials, they just want to shut down Alligator Alcatraz. The plaintiffs allege the federal defendants were required to prepare an environmental impact statement. By failing to do so, they violated the Administrative Procedure Act. The left has been loving this Administrative Procedure Act since the lawfare began against Trump. Just a reminder of why this Administrative Procedure Act exists. And a reminder that since it was enacted into law, the left has hated the Administrative Procedure Act. And that's because the United States government in decades past created dozens of so-called independent government agencies, answerable to nobody, completely lacking in constitutional legitimacy. We have 3 branches of government under our U.S. Constitution. Article 1, legislative. Article 2, executive. Article 3, judicial, the apolitical branch of government. There is no 4th branch of government that says independent agencies. And because these independent agencies are not answerable to the political will of the American people, they act like tyrants act, because that's what a tyrant is. A tyrant is somebody who rules over people to whom the tyrant is not politically accountable. So these agencies would mandate orders and rules on all the rest of us that could financially destroy us, put us in prison if we don't obey them, if we don't bend the knee to their preferences of policy. And many of these were insane. These were rules created by the half of the population that has an IQ under 100. These were rules created after the federal government was no longer allowed to use a civil service exam in hiring. Effectively, the civil service exam was an IQ test. So we eliminated the IQ test. The government started hiring American demographics that demonstrably have a lower IQ than the population overall. And these are the people we put in charge of making rules for us. And when you put a bunch of dummies in charge of making rules, it's no surprise when the rules are idiocy, arbitrary, and capricious. So finally, the people had enough, and the legitimate branch of government that is answerable to the American people, the Article 1 legislative branch, created a law called the Administrative Procedure Act. And the Administrative Procedure Act says if a government agency creates a rule, a policy that is arbitrary and capricious, the American people can sue in federal court to stop that rule. Makes sense, right? What's happening there? The Administrative Procedure Act is protecting the American people from the government, protecting the American people from the so-called independent agencies and their insane, arbitrary, and capricious rules. Sounds great, right? That's why the left hates, until the last 7 months, hates the Administrative Procedure Act. Because how does the left impose most of its insane mandates on us? It's through these independent agencies that they dominate in a position where they have no accountability to the political will of the American people. They love the independent agencies. They want them to have the maximum amount of power over us, and anything that checks the power of the independent agencies, which is what the Administrative Procedure Act is supposed to do, the left hates. That's checking their power. They don't want that. Can't have the American citizens having a role in how their government rules over them. If we wanted that, we wouldn't have created these independent agencies in the first place. So that's the purpose of the APA, the Administrative Procedure Act. The purpose is to protect the American people from the independent agencies, from the government. But how is the APA being used by the left now, the last 7 months in its lawfare against our elected Article 2 executive branch president? It's being used to protect the government from the political will of the American people, the exact reverse of the intent of the APA. The left cares about nothing of principle. The left cares about power and outcomes, and the end justifies the means. They will flip a principled position in an instant if the inverse of what they were arguing a moment before will secure them more power over you. All right, the plaintiffs sought a temporary restraining order and a preliminary injunction to stop the pro-American forces from developing Alligator Alcatraz to try to get a handle on the tsunami of illegal third world migrants invading our nation, consuming our scarce American resources, housing, education, employment, healthcare, social services, space on our roadways, our Costco's, our Ikeas, everything like human locusts. On July 17th, the anti-American forces again asked for a temporary restraining order, explaining that since they filed their lawsuit initially, as many as 900 people have been detained at Alligator Alcatraz. They modified their request for injunctive relief, a TRO or preliminary injunction that, again, is supposed to freeze the status quo, right? Not make changes, asking the unelected black-robed tyrannical inferior district trial court to order our government, America, to cease further construction at Alligator Alcatraz and any operations related to detaining additional detainees. The defendants, our American government, asserted that the venue, So Trump, this is where that comes up. Trump, our government, the pro-American forces, also argued, counter to this, that this wasn't even in the right court. That this was another case where we had an unelected black-robed tyrannical inferior district trial court judge acting without jurisdiction, meaning without legal authority. This was judge shopping. This was put in the Southern District of Florida, Miami, one of the few blue areas of the deep red state of Florida, because they were shopping for a judge that would be favorable to shutting down Alligator Alcatraz. As a matter of policy, not of law, of policy. So the plaintiffs here, the anti-American pro-illegal migrant forces, filed this in the Southern District of Florida, even though only 2% of Alligator Alcatraz falls within the Southern District, because that's where they knew they would find a friendly judge. And so Trump says, hey, this is BS. This is judge shopping. This is not the right forum for this suit. 98% of Alligator Alcatraz is in the Middle District of Florida, federal court, and that's where this should be. But of course, the unelected black-robed tyrannical district trial court judge, who was given this case, doesn't care about jurisdiction. She only cares about outcomes and power. She held an evidentiary hearing over 4 days, heard 10 witnesses, over 100 exhibits. Plaintiffs wanted their temporary restraining order, saying the defendants were planning more construction. And the defendants were unwilling to represent that no construction would occur over the weekend. Why should they agree? So, of course, the trial court granted the TRO halting further expansion. TROs are valid for 14 days, and then they either expire or they get turned into a more durable preliminary injunction. Of course, the unelected black-robed tyrannical inferior district trial court judge ultimately did convert the TRO into a durable preliminary injunction based on the APA claims. All right, so the district court, of course, grants the preliminary injunction against Trump. Where have we seen this before? August 21st, not very long ago, August 21st, the district court, the unelected black-robed tyrannical inferior district federal court judge enters this injunction. Was that even 2 weeks ago? It was just 2 weeks ago. And this decision came down yesterday. So within a 2-week window, this Court of Appeals slapped down this stupid federal judge in Miami-Dade County. That is quick, folks. They don't have to be that quick. That is quick. So on August 21st, the unelected black-robed tyrannical inferior district trial court judge entered a preliminary injunction prohibiting further construction and prohibiting more detainees being brought there. It also required the defendants to remove within 60 days all fencing, lighting, and utilities that were installed to support the detention facility. A timely notice of appeal was filed. On August 23rd, the defendants filed a motion with the district court to pause that preliminary injunction. What do you think the district court said? She said nothing. She just ignored it. The district court failed to rule on that request. And so the defendants on August 26th filed this Court of Appeals motion to freeze that preliminary injunction to dismantle Alligator Alley, as well as a motion for an administrative stay. The district court, the trial court, has since denied the Trump request to pause the stay herself. Standard of review. In considering whether to pause a preliminary injunction issued by an unelected black-robed tyrannical inferior district trial court judge, we applied the usual standards of review for a preliminary injunction. We examined the district court's grant of the preliminary injunction for abuse of discretion. So a lot of deference is given to the lower court. What this means is the Court of Appeals doesn't want to do the job of the trial court. Right? Most Court of Appeals judges used to be trial court judges, and they got promoted to the Court of Appeals. And it's the trial court that's supposed to hear witnesses, hear testimony, see evidence, make decisions based on that evidence. Like the Court of Appeals doesn't have witnesses appear before it. So it can't evaluate the credibility of witnesses and so forth. That's the job for the Court of Appeals. For the district trial court. And the Court of Appeals does not want to replicate all that. So what they say is, listen, we're going to honor. We may disagree with the trial court says. We may say if we were sitting in the trial court judge's position, we would have come to a different conclusion. But unless the trial court abused its discretion, we're going to stick with their decision. We're going to give them that deference because that's their job and we don't want to redo their job. So they'll only reverse for abuse of discretion. Spoiler, this Court of Appeals found abuse of discretion.